Well, thank you very much to Andres Boyce and other organizers of this meeting to invite me to present the next session. I'm sorry for my language, it's not the best, but I hope it's functional, and especially if we have after some reflections or questions. Well, in this session, we have in the first speech, it will be by Pedro Telles. He's senior lecturer of Swansea University. The name of his speech is Abuse of Dominant Position Enforcement. Go quick or go home. Thanks.
Okay. Thank you very much for the introduction. Couple of notes. First of all, my area of research is mostly public procurement and non-competition, so I'll be straddling outside of my comfort zone. So feel free to push back if anything I say is too contentious. And then the second point is I usually like to walk during my talks, but I'm not able to do that. So I'm really working, outside my comfort environment here by being forced to sit and talk sitting. But anyway, I'm going to try and make it interesting for the next half an hour or so. Now, how did I come to this idea or this concept of abuse of dominant position, go quick or go home? Was very simply the fact that I like technology, so I pay a lot of attention to technology. And I follow a lot of people on Twitter that talk about technology from a business perspective. And a few years ago, it came to my mind that perhaps technology was evolving a little bit too quickly for traditional antitrust or competition law enforcement mechanisms to be as operative as they've been in the past. And this is a tweet from earlier this year, so from last month, from Benedict Evans. He used to be a technology analyst based in the UK, and he is now a venture capitalist investor with Andreessen Horowitz, which is a big VC firm in the US. And this is what he says about technology and antitrust. It's a basic feature of the free market that dominant companies tend not to last. They fail or are overtaken or become irrelevant. It's also a basic feature of the free market that sometimes you need state intervention to address this market failure. The difference in tech is that the cycle time can be really fast. We went from IBM to Intel to GAFA in 20-year jumps. That has tended to mean dominance turns to irrelevance faster than antitrust processes can diagnose, pick a remedy, and apply it. And this is the crux of my idea and my argument, especially this last sentence. Dominance turns to irrelevance faster than antitrust processes can diagnose, pick a remedy, and apply it in at least a few technology sectors. So I could stop the presentation here, and this would be what I had to tell you, but I think it's important for us to unpack and unpick a little bit this concept and this idea. So for the next 25 minutes or 27 minutes, I'll be looking at the duration of enforcement in the EU in terms of abuse of dominant position, then the evolving landscape of consumer technology, and then finally potential solutions for the problem. I think that when you get to the end, especially the potential solutions, you'll see that my presentation will dovetail well with Mark's presentation this morning, because I picked up on similar problems and similar issues as well. So let's look at the duration of abuse enforcement in terms of process. Now, I'm going to say that this is a working paper, and the emphasis is on working. So what I found out so far is when it comes down to the General Court and the Court of Justice, on average, the court has become a lot quicker than it used to be in the past in terms of producing its decisions. So historically, processes in the court would take many years to be settled with the final decision, and nowadays they're much quicker than they used to be. One of the reasons for that being that they've increased the number of judges and also the number of advocate generals, and they will increase again in 2019 so that we'll have 2 judges per member state. Now, what I could not find, and I tried it, was looking at the Commission itself. How long does it take for the Commission on average to try and figure out and investigate competition law infringements? And I couldn't find that data. So I don't know exactly how long does it take on average for the Commission to, once it receives a complaint, then to actually act on the complaint, investigate, and produce a decision. I just don't know. And also something that we don't know is how long does it take to enforce a final decision. So there's a number of cases whereby the companies were found to be in violation of abuse of dominant position. Let's talk about, for example, Microsoft or Intel, that I will be mentioning further down. But the actual remedies were only enforced after the final decision from the Court of Justice, because they had been dragging their feet until then. This is to say that effectively, from start to finish, from the moment infringement occurs to the actual final decision and the final enforcement of the remedies, we may have, for example, 10 years going on between the infringement and the final decision. And to me, this looks like a little bit too long, at least for some of the sectors that we're going to be talking about. So an infringement that happens in 2010 may lead to a complaint in 2012, may lead to a decision by the Commission in 2016, and may lead to a final decision by the Court of Justice, let's say, in 2020. Now, what may happen in the meanwhile is that the infringement, instead of stopping immediately, may continue until we have the decision by the Commission, or it may still continue afterwards because, compliance is not great when companies don't want to comply with decisions. So the infringement may continue. So the effect on the market, the abuse of dominant position, may remain in place for a very long period of time. So what's the consequence that it will have in the market? I suspect that the consequence is that it will affect the market, it will affect the other market players, and also will have an effect on consumers. So when we look at this, we can look at the enforcement of competition law and think about life cycles of elephants and fruit flies. Now, the current system that we have today is perfect for life cycles and evolution of elephants. Elephants have long lifespans, so the evolution of elephants happens slowly. So something that takes 10 years to decide in a court of justice, or in a court of law, it's not problematic in that sense. Now, it is very different when we start to looking at technologies and when we start to looking at dominances that are measured in life cycles of fruit flies instead of elephants. If the underlying enforcement process takes the same for both, what was effective for the elephants is not effective for the fruit flies. And that, in a sense, is what I think is happening with the abuse of dominance position in terms of enforcement at EU level. Now, if you think about it, there are a few technologies or sectors that don't change overall or take a long time to change. For example, we still use more or less the same toilet paper that we used 20 or 50 years ago, irrespective of the branding associated with it. Nappies. I'm a young father, so nappies have evolved, apparently, according to my mother. Nappies have evolved a lot over the last 30 or 40 years, but not enough to actually disrupt the market fundamentally. So it's still more or less the same players. So there are a few sectors that, even technology-enabled sectors that will still work as relevant in terms of their life cycles, whereas we have others, which have been discussed this morning in terms of data models, for example, which work instead more like fruit flies, and they change a lot more quickly. So let's look at those in terms of the evolving landscape of consumer technology. When I have audiences and when I'm speaking, I like to turn the tables to the audiences, because it's boring to keep on listening to the same guy for half an hour on one go. So I've got a question for you, which is actually 3 questions. So I'd like to know, what is your opinion? Let's think about decades, okay? How long have these technologies taken to reach 90% of the population in developed markets? Any ideas? The landline phone, how long did it take?
80 years.
Maybe 80 years. So, you have a pen for me to use the whiteboard? Yeah. So, first technology might have taken 80 years. Second technology, how long did it take? 20 years. And the third one? 5.
Even less.
Sorry, someone said?
Even less.
Even less. Well, almost. So this is using US data. You can see that for the telephone to reach to reach 50% of the market, it took 40 years, then another 12 to get to 75, and then another 20 to get to the 90%. So that is, I think, 78 years or something. So you were bang on the money with that figure. The cellular phone was a lot quicker, and so we have it reached 50% in around 10 years, and then 8 for the 75 and 90% thresholds. And the smartphone was faster still, but is yet, as far as I know, is yet to reach 90%. But the trend is clear. Or at least on this technology, the life cycle of the technology is becoming a lot shorter. So you're moving from the elephant life cycle of the telephone to perhaps the life cycle of the fruit fly at the smartphone level. Now, the problem is, in terms of enforcement, as we've discussed before, the duration of the enforcement is taking pretty much the same time. Now, there's one thing else that you can say about this graph, is that you can say, Pedro, you're cherry picking your data, so you're picking the example that best fits your preconceived notion. I'll say, true, but there are other examples that I could use. I just picked the one that is most, visual. It's easier to sell and easier to visualize. I could talk about TVs, for example, black and white TVs, color screen TVs, high definition TVs. I could talk about VCR in comparison with the DVD and then with the Blu-ray. I could talk about a number of other consumer technologies, which with every new generation of that technology or the same use, the penetration happen a lot quicker. That doesn't mean that technology disappears. So you can still buy a landline phone today, but it means that it's no longer economically as important as it used to be in the past. So whereas today we pay attention to the brands of our smartphones, no one today pays any attention to the brand of their landline phone. Is whatever there is at home. We just don't care. So the economic value of that technology has been subsumed and has been replaced by something newer and better tuned to the uses of today's world. So my theory and my point, when it comes down to some technology sectors, is that new technologies displace the older ones, and they're doing so at a much faster rate than before. So it leads to the older technology becoming irrelevant more quickly. And in consequence, if we associate the technology to the dominance, so for example, let's not forget that with new technology, we may have patents attached, and that is basically a state-granted monopoly on that technology. If that happens, effectively what it means is that the dominance periods are getting shorter because there's a new technology coming to replace the old one, and that will make the first one fade more quickly. Now, with this context, how do we make remedies that are effective and on time in terms of abuse of dominant position? And for that, let's look at what has happened over the last few years in terms of cases, or important cases in consumer technology that have gone through the Court of Justice. And I'm going to start with 2 old school cases that I suspect all of you know in one way or form. First one, the Microsoft case, and then the Intel case. Both of them took more than 10 years to sort. And both of them had led to remedies that, once they became definitive and effective, they were no longer relevant for the purposes that they had originally been designed for, because the market had changed. And that was with stuff that happened and with technology that happened that was relevant maybe 20, 25 years ago or 15 years ago. Today, it's happening even more quickly. So let's look at a more recent case, the Google Shopping or the Google Shopper case. Do you have any ideas when that one started? 2000? Nope. 2008. 2007 or 2008. And we had the final decision. Oh, sorry, we had the Commission's decision last year in 2017. So we know that the complaint is from 2007. We know that the Commission opened the investigation in 2010. Then it took them 7 years to reach a decision. We are yet to have a decision by the General Court, and we may have a decision by the Court of Justice as well. What we don't know exactly is when did infringement start? We don't know. we know that there was a complaint in 2007, so we know that the infringement, or the alleged infringement, started at least in 2007 and has remained ongoing until 2017. So there's a decade there where Google was, in accordance with the Commission, was abusing its dominant position. Now, the landscape, and the search landscape might have looked a lot different had the Commission acted more quickly and the decision had been produced more quickly, but this is what we have now. And one of the problems we have in this sector, or in this area in terms of competition law, in my view, is the counterfactual. How do we deal with the counterfactual? It's really hard to say, oh, the world would have been something completely different. We just don't know. It's very hard to play the counterfactual case. Now, if that wasn't enough, let's talk about cases that are ongoing. Let's talk about the Android case and Google AdSense. Those are ongoing. There's still no decision by the Commission, and we don't know when we're going to have the decision by the Commission or when there's going to be any decisions by the Court of Justice, be it the General Court or the actual Court of Justice itself. Google AdSense is, as you may well be aware, Google's bread and butter. That's where they make 80 or 90% of their income and most of their profit as well. Android is a play to remain relevant on a mobile world. So they don't charge for it. They allow system integrators to use it for free with some strings attached. But for the most part, that's what they use it for. Now, the interesting thing about Android is you may or may not be aware that Google has been for at least 5 years, as far as we know, developing in-house a replacement for Android. Because Android relies on a number of technologies that are open source. It's derived from Linux, and that comes with a number of technical issues and hurdles that Google wants to solve by controlling the whole stack. And this means that by the time that the Commission comes out with something against Android, Google may have replaced Android with that other operating system. And then any remedies that target Android specifically will become pretty much irrelevant quite quickly. So this is another example of the risk that we have of a slow-moving enforcement mechanism of abuse of dominant position. Because personally, I have no reasons to doubt that Google has been abusing its dominant position on Android by forcing system integrators to use their own apps and tools in detriment of others, like Microsoft did 20 years ago with Windows and Internet Explorer. Now, just to finish it off, how long do I have? I'm halfway through. Okay. Let's look at potential solutions. What can we do? Now, I'm working on these 5 potential solutions, and I'll be talking about the first 3 because the last 2 are more pointers towards what I want to be developing in the next stages of my paper than stuff that I'm comfortable discussing in detail. But if you want, we can talk about that. So I think there are at least 3 options we could look at in terms of trying to change how the abuse of dominant position in terms of technology is dealt with at EU level. We can be speeding up enforcement, as it was discussed this morning, perhaps moving the emphasis to merger control, or we could accept failure. So let's bring back this slide. Now, the court is doing its bit. I'm yet to find out the average duration for competition law cases in the court, so this is just average for the court in general. So I wouldn't be surprised that on average competition law cases last for longer and tend to last for longer to get a decision than the average. But I would say that in terms of improving and speeding up enforcement, I would say that the low-hanging fruit is probably in the Commission side. The Commission has, according to Regulation 1, 2003, I can't remember the article, maybe Article 23 or 24, has a time limit of 3 to 5 years after it receives a complaint or is aware of the alleged infringement to start proceedings against the company. But there's a number of interruptions that can happen. a number of interruptions that can happen on that time limit. So that explains why, for example, in the Google Shopper case, we ended up with a decision in 2017 after something that was raised 10 years before with them. So I suspect that looking at how the Commission operates and in speeding that bit up might be the low-hanging fruit in terms of speeding up enforcement. I don't know exactly, and I mean, I'm a EU lawyer in general, so I cannot think about how can you speed up the General Court and the Court of Justice more than we've done already, other than actually playing around with very important stuff like reducing the possibilities of appeals, or for example, as well, creating a specific status for competition law cases to proceed more quickly, to give precedence over other cases. That I think is just fiddling with the system too much. So perhaps looking at how the Commission does its investigations would be a good point to start. Now, if we move the emphasis to merger control, we would be looking at situations like this one that was also mentioned this morning, what Facebook did in the last few years. And what Facebook did in the last few years can be described very simply as buying its way out of irrelevance. In the sense that Facebook, as a company and as a product, works well around certain use cases in a certain demographic. It's not used by other demographics, namely younger people. So Facebook's penetration on teenagers and people that are in their earlier 20s is much lower than it is on my generation, for example. So what they did is they bought the social networks that were more prevalent in those age groups. First, Instagram, then WhatsApp, and then just last year, the one that is probably the most popular with teenagers at this moment in time, and it's not Snapchat. It's the other one on the top left corner, which is TBH, to be honest. They were allowed to buy them without any sort of control, all of them. So to move the enforcement to moving the emphasis to merger control means paying a lot more attention to these decisions. So that, again, it goes in line with some of the conversations we had this morning. But I like to criticize my own views and my own opinions, and the problem here is one of hindsight being 2020. We can now say that, well, it was obvious that WhatsApp would be used by the ways that Facebook did use it for, and it was obvious that WhatsApp would become a predominant social network after being acquired by Facebook. But again, it goes back to the counterfactual. What if WhatsApp had not been acquired by Facebook? What if Facebook, instead of buying WhatsApp, what if they rolled out features that are just identical to WhatsApp, which is what they're doing with Instagram in terms of copying Snapchat. They never acquired Snapchat, they just copy their ideas. So it's really difficult to go down this route as well. And as I said, hindsight is 2020. When you look back, everything looks obvious. So let's look forward. Let's assume that artificial intelligence is the next big thing. It's the next technological revolution that will reshape technology, or will shape the marketplace. Here's a tweet by another analyst. Number of artificial intelligence AI startup acquisitions since 2010. Google 14, Apple 13, Facebook 6, Amazon 5, and there were other companies in the tweet that I deleted. So we don't know if that is going to be the case or not. So if we think that we should be investing more in terms of merger control, or being more careful with merger control, then we should be paying attention to these acquisitions. Because those may be, in the future, what allows Google, Apple, Facebook, and Amazon to make the transition to that world. But if we do that, then we soon get into the law of unintended consequences. When should it be done in terms of market maturity? The AI market is not mature. We know that. But we don't know how long it's going to take until it becomes mature. We just hope that we'll know that it becomes mature, and we'll know it when it happens. And then more importantly, what will it do to entrepreneurship? If we close down the avenue of companies being acquired by main players, startups being acquired by main players, will it lead to actually less companies being started in the first place. So you actually have less startups, so you have less competition. So you reduce the probabilities that actually someone will disrupt those companies and will provide more consumer surplus than you have today. And also, in terms of how the Commission operates, this would imply a significant change on enforcement priorities. It would imply the Commission recognizing that what it's doing now doesn't work for at least a few sectors, and perhaps it would be preferable to focus on this and change enforcement priorities accordingly. And then we've got the last one, which is abandoning enforcement of abuse of dominant position, which is pretty much what the Americans have been doing for the last 20 years. Well, the market will sort itself. This would be more than a significant change, would be a complete overhaul and change in concept in the way that competition law works in the EU, in at least those few sectors that are prone to technological churn and change in smaller periods of time. It's also recognition that it's not only impossible in terms of timescale to deal with them properly, but it's also probably impossible to deal with them in terms of remedies. So it's no surprise that this morning we saw so much being talked about how do you craft effective remedies for these sectors. It's really hard. I don't know if you noticed this, but the Commission did something that I found it amazingly, how can I say this in English? Disturbing in the Google Shopper case. In the Google Shopper case, the Commission did not set out the remedies. The Commission said to Google, you define the remedies, and I'll tell you if you're complying with my decision or not. And when I read that, it reminded me of my parents when I was a kid and I used to make mistakes. They would say to me, you pick the punishment, and then I'll tell you if the punishment is good enough for what you've done. And it's the same logic. It's a cop-out. It's the Commission recognizing it's unable to come up with remedies that are effective because they just don't know enough. And that's how I read it. They just don't know enough about what's happening inside of Google so that they can come up themselves with a specific remedy. So designing remedies, effective remedies, is difficult. But again, I don't find this as a good enough solution. And the reason for that being that given enough time, any and every technology is replaced and is also displaced. I mean, that's the story of humanity. All the technologies we have today, all of them displace something else. And all of those that we have today will be displaced by something else in the future. It's just a question of time and timescales. Even oil. I mean, if you take oil as a technology, it has been used and has been a predominant source of energy and mobility for over 100 years. Its prevalence may disappear within the next 10, 20, or 25 years. And it's not going to happen because we ran out of oil. It's just because we found a new way or better ways to move ourselves. So given enough time, every single technology will be displaced. So why should we treat some technologies different just because the dominance period is shorter than it is for other technologies? Why should we do that? And I think that is a fundamental question I like to end my presentation with, which is, in terms of a legal framework, an enforcement framework, are we comfortable or not in accepting that there are sectors where we cannot deal with abuse of dominant position in an effective way? If you're happy with that, where do we draw the line? And that's what I wanted to say to you. Thank you very much.
Well, thank you very much, Pedro Telles. Really, it has been very suggestive for me, and I don't know if it's polite because since 2004 we have been making some congresses, and as a joke, more or less, but I always say that it seems that it's a meeting of Alcoholics Anonymous because one person is in the IT law. I work not in competition, never, but in IT law and fundamental rights and that. And normally what the person with his speech make all the questions and all the problems we have and not always with solutions. No? And the big problem we have, and you have exposed very, very well, today I'm working about algorithmic regulation, big data, robotics, and the problem it has been the same in the last 20 years. And I recently read about the Colin Wright's paradox, they call it. Colin Wright is an author that in the 80s, the beginnings of the 80s, he wrote about the control social of the social control of technology. And the paradox is, the point we have always is not the same, because in the case of competition, probably we can ask, and people will ask probably to you, what are the reasons that the process is so slow? But normally it's a problem of regulation. In this case, it's application of law, but normally we have the problem of good regulation and regulation on time. And the paradox of Colin Wright is that at the beginning with technology, there are some interest, but also we are ignorant of the problems. Law is slow, and at the moment when the law and the lawyers and the legislation is possibly to make is possible to make the legislation is so late. And the problems are different, and it's the paradox, and we have been more than 20 years making speculations and that, and for that reason I say we have the same problem as alcoholics, IT lawyers, because say, well, what's happening? Because it happens with internet at the beginning, in the early 2000, and today with robotics and algorithms, we have the same problem, because the EU Parliament is starting to think about legislation. The Federal Commission of Telecommunications is starting to make some proposals, and probably it will arrive when the monsters you have been talking about, they have bought all the companies of artificial intelligence. Well, I am sorry. And another suggestion. Recently I read another way to make law. It was from the Council of Europe, one parliamentary, he makes the report on regulation of robotics, and he told about biodegradable rules. Rules to resolve the moment the concrete problem we have, because if we ask for a permanent legislation, probably we don't solve any problem, or it will be so late. Biodegradable rules. I don't know if it's the good way, the liquid law, the liquid society. I don't know if it's the way, but probably I think, and I'm sorry, because my language is very bad, then I am more slow. But your question, do you think that it's better to have quick reaction or longer reaction but late? But I'm sorry, it will be after the questions of the public or some suggestions. There are three hands.
Oh my God, what have I done?
Confused everybody, no.
Please.
A comment that maybe would be interesting in your timetable, the analysis of like if there any kind of incentive in terms of
This one?
no with this one.
Okay.
No, maybe another one, the next one maybe. No, the one with the infringement in red.
Okay, sorry. Hold on. I'll go back. Yeah.
Okay.
Can use this one.
That the infringement will be until the decision.
At least until the decision,
At
yes.
least, but I don't know like how the incentives work. I mean, like the incentive for the company to stop the abusive conduct when the competition authority starts with the investigation. Maybe this is I don't know, something that would be interesting to analyze, because we are talking about how the incentives of stopping the infringement would work, and it seems that nowadays some companies, at least, they prefer to take the risk and continue with infringement until receiving like a kind of fine or something like that.
Yeah, can I answer?
Yeah.
So the question is, how do we change the incentive so that infringement stops earlier? Is that the question?
was just a comment that
A comment,
I think
okay.
it's interesting to,
Yeah.
to if there's information about, because I
You're-
was working in a competition authority in Chile.
Okay.
And one of the important things that we analyze when we analyze conducts and infringement in general is that, we started with this investigation, and when that happened, after a few months, the company changed completely the conduct in the market. So
Okay. My answer is it depends on the market. In market where there are network effects in terms of winner takes all, the incentive is built in for the infringement to continue until as late as possible. And you also have to remember that then you have the incentives, for example, of the directors in that company, that they are there today, and if they stall the process for as long as possible, they may leave the company in the meanwhile, and it will not happen under their watch. So it's one thing that there's an incentive of the company, and there's an incentive of the individuals running the company, and they are not necessarily aligned. So this is basically agent principle theory. I suspect that in markets where there is a winner takes all mentality, and any market which is prone to network effects, like operating systems, like social networks, and that kind of stuff, there's an inbuilt incentive for the abuse of dominant position, if it exists, to continue for as long as possible, and to delay the inevitable for as long as possible. So Google will be delaying the inevitable on Google Shopper for as long as possible. On Android, if there's a decision, the same, unless they switch to a new technology, and then they just don't care.
okay, just to complete the comments, it's in relation to what's answered, that maybe this trend exists because there are or there were no guidelines so I mean I'm not saying that it would be an answer, but maybe if you have like clearly strong rules, maybe the analysis of risks will be different, and maybe in a non-mature regulation environment in which you don't know how to deal with this digital new world.
If you want to solve this by the incentives side of thing, you have to impose a very high reputational risk and reputational cost into the infringer. And even with if you look at the Regulation 1/2003 and also the enforcement priorities, there is an emphasis on fines as if fines would solve the problem. They don't. They're just a blip. I mean, fines, 10% of turnover, it's still preferable to have done the infringing conduct because you had a number of years where you actually had all the turnover benefiting from that infringement. So if you pay 10%, that is a running error on a long scheme of things. So I find it really hard unless you really increase the reputational cost, and not only the reputational cost but also the certainty of punishment. It's really, really hard. So will we be looking for something, for example, looking out of the box, looking into actual criminal proceedings against the directors, for example? That is a touchy subject. It's not something that I've explored, but that may change the mentality and how people operate. I don't know.
There were one hunter.
So it seems to me, I agree with your main concern. So you say to the people that say that the markets will self-correct themselves in the long run, change something in the long run, we will all be dead.
Exactly.
And I agree with that. But your beautiful graph with telephone, the technology life cycle, made me think of the following thing, that actually if it's not complemented by some additional graph, it gives an argument to your opponent. Because here, for example, we see that technological life cycles are shorter.
Yes.
Which means that dominance necessarily is also shorter.
Yes.
It's also more ephemeral. So if it's short transient and there is a disruptive innovator, then this might not be a problem.
But
for example, if, just to finish up, so my point is, if we don't complement this empirical data by data about the concentration rates of these markets, the output levels, the number of the market players, the picture is not complete. Because if we look at data, and I will just, if we look at evidence from the smartphone market, from 2007 to 2014, output has exponentially increased.
Correct.
And also I read that over the, with smartphone sales to end users have increased worldwide by 900%.
But that is what I meant by the penetration rate.
Yeah, but if we have a disruptive technology, and this technology really spreads across the market,
Yes.
and then we have multiple players that fiercely compete with each other, then
Okay.
where is the need to intervene?
So tell me, when it comes down to smartphones, well, there's only the need to intervene if there's a dominant position. Okay? If there's no dominant position, there's obviously no need to intervene. Now, I remember back in 2007 that you could buy phones with different smartphone operating systems. So you could buy an iPhone, which runs iOS. You could buy any Android phone that would run Android. You could buy a BlackBerry phone that would run BlackBerry. You could buy a Nokia phone that at the time ran a Nokia smartphone OS. And you could also buy some phones that were made by HP, which run Palm. And you also could buy Microsoft phones with Microsoft OS or Windows OS. So that's 6. We're now down to 2.
Yeah, but does more choice mean less choice means less efficiency?
No,
Or
it
more
means
choice
it means that we have a dominant position, and it means that we may or may not have an abuse of dominant position. What I'm saying is, because the cycles are shorter, and because there is a technology that wins, it's more likely that it's going to be a single technology. So it's more likely that you're going to have dominance, even though that dominance is shorter.
Yeah, my problem with smartphones is just that the data I see characterize markets within HHI terms from 2007 to 2014, going from highly concentrated to unconcentrated. So, I mean, there might be less choice in operating systems because inefficient operating systems were abandoned, but it seems to me that these markets, since they have output increase, they are competitive.
So tell me then, why is the Commission looking into Android? Because that's my point. My point is not my point. I'm not making the point about device makers. I'm making the point, or I could be making the point about device makers, but I'm in this case, I'm making the point in terms of smartphones of the operating systems that they run.
Okay.
And you can have the discussion. Look, can have a discussion afterwards if you want in more detail.
Yeah, yeah.
Okay.
Marco Botta.
Thank you for the interesting presentation. I think you are talking about debate somehow. So this is not the
Please.
problem.
Little bit
It's
allowed
not
for the
the
rest.
problem only for technology
No.
markets. We saw recently the settlement with Gazprom decided after so many cases of investigation and attempts to settle. So my question is the following: in order to somehow strengthen, let's say, your argument, if you also are you considering to have a look at the timing which is needed by the National Competition Authority to investigate cases under Article 102? Because I think the national authorities are usually quicker than the European Commission. They don't need 8 years to decide a case. Also, the judicial review is quicker at the national level.
Oh, it
And
depends. It depends on the country.
but I think the Bundeskartellamt will decide the Facebook case in 2 years' time if they decide by the summer. And also, I think at that point, you could then discuss what are the institutional issues in DG competition which lead to these delays.
So,
These are just a
so
comment.
the answer is very simple. It's no, because my bias is, as a EU lawyer, is to look at issues from a EU perspective. So my hammer is the EU law hammer and the EU law enforcement hammer. So I have not considered and not looked into the national competition authorities and how quick they are into taking steps against players' abuse of dominant positions in new markets. I know that in France, for example, they're doing it a little bit differently. For example, with the App Store, Apple App Store. So instead of actually using competition law, they're using I think it's consumer rights or consumer protection law against it. But I have not looked into that angle.
Yes, there are 2 more questions there. Well, maybe 3, but for the next speaker. But in relation with that, do you think there is a special will of the Commission to play with the time? Because in Spain, for example, This is very typical for our constitutional court that sometimes for 13 years we have to hope, to wait. But do you think there is a special will in the Commission, or this only a procedural and legal warranties problem?
I was on Twitter yesterday, and someone said very aptly, or was linking very happily for a profile of Margaret Vestager, the commissioner, and saying it's impossible to understand EU Commission or competition law policy today without understanding the drivers and the incentives behind the commissioner. And obviously, as far as we know, she wants to run for president of the commission. That's why she's so interventionist today, and has been for the whole of her mandate, in comparison with Joaquin Almunia was there before her. So I think it's, unfortunately, the commission works at not at the speed, or not subject to the legal requirements that one would expect in that day to be followed, but sometimes due to the political driver at the top. And that is my impression of talking with people, not necessarily on competition, but talking with people and colleagues in the commission. That is what they tell me. It depends a lot on political drivers for actions to be taken and to be followed up in a certain way.
Well, there. Thanks.
Basically, actually, two small questions that are really practical.
Okay.
One is that I think I agree with you that when we use a lot of sections is at the commission level. So the question would be, how do you know maybe,
Sorry, I can't hear you. Sorry.
so do you know maybe which parts of the inquiry of the commission takes more time? So is it the proof gathering, the analysis? Because if we know which parts take more time, you might actually take out a part, or like just invent. I mean, the general court or the CGU saved a lot of time just by throwing money at the problem and enlarging their,
Yeah.
percent. Would that be, I mean, depending on what the problem is, that could be a solution of the commission as well. So do you have, and just a small second question, is that about the Google case, you said that they found a solution to go faster, basically, in saying, okay, propose us a remedy, and we see if that's okay or not with us. And you say this is an admission of ignorance, basically. But couldn't you also analyze it as the idea that, you know what, we don't want to work necessarily against you. You're Google, you've done some good things, we need you on the market. What you do is wrong, but we don't want to kill you. We want you to stop that. And we want you to find a way for you to stop it that we think is acceptable, and we work together towards it. So do you think, and I know that this might seem crazy for you, but do you think that there might be some of that way?
Okay, regarding the first question, my answer is no, I do not know exactly how it operates. So that is an area that I need to work more on to try to figure out what is happening. I was trying to hope that, looking at their early reports, I could find more stuff about it. I can't. All I can see is almost a list of, this is the investigations that we're doing. Okay, thank you. But I want to, the subject and analysis saying, we're spending time on this this sector, or we're spending time on this action, or that, whatever. And the information is not there, unfortunately. As for the second question, I remember back in 2014, during the Barroso Commission, how close the Commission and Joaquin Almunia as a Commission back then was to signing a settlement with Google. The fact that it wasn't signed, and the fact that the Commission then decided to go on an adversarial route against Google, makes me think that, at least in this case, it's not that they're working together to solve the abuse of dominant position. My take, and it's purely my personal take, is this is a recognition of inability from the Commission to actually propose a remedy that they know that it works. So they're basically passing the risk back to the company.